Welcome back, future criminologists. In this video, I will be discussing presidential or executive immunity. Before discussing what is presidential or executive immunity, I will distinguish first term and tenure. These two concepts are material in discussing presidential or executive immunity. Term is a fixed period for which something, that is, office, imprisonment, or investment, lasts or is intended to last. While tenure is a period of time during which something is possessed. For example, in the Philippines, the president serves a single fixed 6-year term. However, if he dies or otherwise become incapacitated after 4 years, then his period of tenure as president is 4 years. Ang tenure ay panahon ng panunungkulan. Ang term ay panahon kung hanggang kailan siya sa kanyang posisyon. Now let us discuss presidential or executive immunity. Presidential or executive immunity is a rule which states that the president is immune from civil and criminal suit during his incumbency or tenure. Yes po, tenure and not term. However, during his tenure, the president may not be prevented from instituting suit. Hindi siya pwedeng kasuhan, pero pwede siyang mangkaso. Next, waiver of the presidential or executive immunity. There is nothing in our laws that would prevent the president from waiving the privilege. He may shed the protection afforded by the privilege. Wala pa atang gumagawa nito eh. However, an impeachment complaint may be filed against him during his tenure. I will discuss impeachment in a separate video, so stay tuned. Next, the constitutionality of presidential immunity. There is no need to provide for it in the Constitution or the law, as it is deemed inherent in the office of the president. Otherwise, it will degrade the dignity of the high office of the president, the head of state, if he can be dragged into court litigations while serving as such. Furthermore, it is important that he be freed from any form of harassment, hindrance, or distraction to enable him to fully attend to the performance of his official duties and functions. Rule on immunity after tenure. Once out of office, even before the end of the 6-year term, immunity for non-official acts is lost. Immunity cannot be claimed to shield a non-sitting president from prosecution for alleged criminal acts done while sitting in office. The rule is that unlawful acts of public officials are not acts of the state, and the officer who acts illegally is not acting as such but stands in the same footing as any other trespasser. A non-sitting president does not enjoy immunity from suit, even though the acts were done during his tenure. The intent of the framers of the Constitution is clear that the immunity of the president from suit is concurrent only with his tenure and not his term. Take note of the words tenure and term. There are two purposes of presidential immunity. First, because of separation of powers, viewed as demanding the executive's independence from the judiciary so that the president should not be subject to the judiciary's whim. Second, public convenience. The grant is to assure the exercise of presidential duties and functions free from any hindrance or distraction, considering that the presidency is a job that aside from requiring all the office holders' time, demands undivided attention. Nature of the presidential or executive immunity. The immunity of the President from suit is personal to the President. It may be invoked only by the President and not by any other person. Such privilege pertains to the President by the virtue of the office and may be invoked only by the holder of that office and not by any other person in his behalf. To end, please subscribe to our channel and stay tuned for more videos.